Yes. Like I said in open court, when we commenced this lawsuit initially in August 2021, there was nothing else we were looking for except justice. We got justice initially before the High Court of Abia State, but it was segmented justice and limited justice to the events of 2017, i.e., the military invasion. So, because of that, we proceeded to the Federal High Court, also in search of justice. And today, justice has been done. Extraordinary rendition has been finally struck down. As a means of bringing a fugitive from one country to the other, the court has made it clear today that extraordinary rendition shall not be tolerated by the judiciary of this country. And in making that clear, the court quite very clearly referred to the Court of Appeal judgment of October 13. So now that the judiciary is speaking with one voice, it's left to the government of the day, the federal government, to retool itself and re-advise itself. What is the judiciary trying to tell the executive branch? The judiciary is simply saying one thing in one voice, that self-determination is not a crime. But when you fight it as a crime, you have to fight it within the confines of the law. That any executive rascality or recklessness or unlawfulness shall not be tolerated by the judiciary. We came before this court today, or rather when we did in March this year, asking the court for 8 reliefs. We came before the court with 8 prayers, and all the 8 prayers were granted. The court held that what happened to Nnamdi Kanu in Kenya was torture. The court held that his manner of being brought into the country is extraordinary rendition. But most importantly, the most important takeaway from this judgment today, I have to tell you, is not the money. We didn't come here looking for money. It's only because the Nigerian Constitution made provisions that when you sue for fundamental rights, you have to tag along a request for money. So we couldn't say, well, we're not going to do that. That's what the law required. So we are not talking about the money. We are talking about restoring him to the status quo as of June 19, 2021. And that is the most important order we got from this court today. So I call on federal government to take prompt steps to obey this court order and restore Mazi Nnamdi Kanu to the status that he was as of June 19, 2021, which was that he was a free man, Her Majesty's subject who entered Britain on a valid passport, entered Kenya on a valid passport, but was extraordinarily renditioned to Nigeria. So this court is saying restore him to the status quo. And that is exactly what I expect the federal government to do. As you can recall, the Court of Appeal discharged him, but it didn't go that far. So if the federal government was relying on anything that it calls a lacuna in that 13th October judgment, of which there is none, it has been made clearer today by this very federal high court that not only has Nnamdi Kanu been discharged by the Court of Appeal in Abuja, the federal high court has ordered you to restore him. Take the extra step of restoring him to his status as a free man as of June 19, 2021. And on a final note, let me also address this specifically to the federal government with all sense of responsibility. A terrorist group does not have lawyers. Anywhere in the world, it doesn't happen. IPOB is not a terrorist group. If it does, it wouldn't have lawyers, lead counsels, and special counsels. Everywhere. In Washington, IPOB has lawyers. In Britain, IPOB has lawyers. And when I say IPOB, I mean IPOB stroke Mazi Nnamdi Kanu. In Kenya, IPOB has lawyers. In Nigeria, IPOB has multitude of lawyers. Point to any terrorist group in the world that has lawyers. Show me any terrorist group in the world that has won a single court judgment. But IPOB has been winning a string of victories. What does that tell you? It tells you that apart from the federal government and that very discriminatory action it took in 2017, declaring IPOB a terrorist organization, no other organ of state including judiciary here today, and judiciary in Abuja on 13th October sees IPOB as a threat to the state or as a terrorist organization. So it's time the federal government goes back to that policy and advises itself and pedal back and eat its own words and say IPOB is not a terrorist organization. IPOB is a law-abiding, non-violent freedom-fighting movement that is seeking a separate state through a means recognized under the laws of Nigeria and the international community. And it's referendum. He never said we want a separate state through war. He says we want a separate state through referendum. A referendum is a call for dialogue. It's not a call for war. So on that note, I shall end this post-judgment press briefing. And if you have any specific questions to ask me, I'll be glad to take. And I may also differ to my colleagues today that I thank so much. They stood by me. This very battle wasn't it was very tough. It was lonely sometimes. So these, my colleagues here, have been the rocks of Gibraltar, standing behind me and providing invaluable professional services to this case. Pierre Gazier, Patrick, I thank you. Prince Mandela Omoborogo, I thank you. I also thank you, Oheto Owazie. And Ohaneze Youth President, Ibuayaka, he has always been standing shoulder to shoulder with me. I'm very grateful. I'm grateful to all that are behind me here. I'm grateful to all of you for your support. Okay. And this support has been very invaluable. It's highly appreciated. And may God bless you.
Barrister, please, how do you reconcile this judgment with the pending suit, the appeal by the federal government that is pending at the Supreme Court in the aftermath of Abuja Court of Appeal judgment?
Well, it doesn't detract from the effectiveness of the judgment today. That case is diametrically different from this one here today. That case concerns a criminal matter that didn't terminate the way it's supposed to terminate at the High Court, and the Court of Appeal held in favor of Nnamdi Kanu. So the federal government, well, took it to appeal. This is a different case altogether. In law, we call this kind of case sui generis. It's of a special class, so nothing can ever taint it. And not that I'm saying that the differentiation is that, but because we have commonality of a client here. We have Mazin Nnamdi Kanu as the common feature here, and the federal government and the Attorney General of the Federation are also parties. But that is as far as the similarity goes in that respect of being parties, common parties. And the second similarity is that the Court of Appeal judgment of 13th October also was relied upon copiously by the court in Omaha today.
Thank you.
Thank you.